Welcome to episode 15, Contractors and Travel. In this episode, you will learn how contractor travel is performed, the type of contract required for contractors to support e-gov, travel services, and the roles contractors can perform with regards to travel administration and travel program management. By the end of this episode, you will learn how contractors travel when performing to a contract, how contractor travel is paid, the relationship of the federal travel regulation to contractor travel, contractor use of strategic travel resources. 3 considerations regarding contractors and travel program support. What are personal services contracts and how they relate to travel programs? The federal travel regulations impact on using contractors to arrange employees' travel and prepare their voucher claims. The department's determinations regarding the use of contractors to perform travel-related program activities. The determinations that must be obtained before a contractor may perform travel program-related work. How to avoid the risk and potential liability associated with the use of contractors for travel program. The federal travel regulations impact on using contractors to arrange employees' travel and prepare their voucher claims. The department's determinations regarding the use of contractors to perform travel-related program activities. The determinations that must be obtained before a contractor may perform travel program-related work. How to avoid the risk and potential liability associated with the use of contractors for travel program activities. What are inherently government functions? The 20 specific types of functions that are inherently governmental and cannot be performed by contractors. The specific travel-related roles/functions that have been determined by the department to be inherently governmental and which cannot be performed by contractors. Duties closely associated with the inherently government functions and how they relate to travel program activities. The following symbols draw your attention to a particular point or topic. The red circle and exclamation point denotes a very important point. The yellow caution triangle denotes a safety note warning that failure to heed the point will likely cause significant issues. The blue exclamation point and banner denotes a best practice. And the blue binoculars denote a case study used to further explain or provide an example. Contractors travel according to the provisions of the contract they perform to. The cost of a contractor's travel is likewise according to the provisions of the contract being performed to. Some contracts do not allow the contractor to travel, but others do. Often, a contract will stipulate the contractor must be approved to travel by the contracting officer's representative or the contracting officer. When a contractor travels, and if the costs are allowed to be billed to the government, then the costs are claimed by the contractor submitting an invoice. The FTR applies only to those whom it defines as employees. In general, the federal travel regulation is not binding upon contractors, whose travel pertains to the performance of a contract. However, sometimes contracts will incorporate sections of the FTR as a guide for how the contractor must travel with regards to mileage reimbursement rates, lodging costs, use of premium class airfare, and other factors. Regardless of whether the contract references the FTR, the contract must be adhered to for all contract-related matters. Contractors arrange their own travel according to the contract and their employing company's policies. Contractors are not employees as defined by the FTR. Contractors cannot use e-gov, travel services to travel, including the e-gov, travel system or the embedded travel management center. Likewise, contractors cannot use strategic sources such as the City Pairs program for airfare, the FedRooms program, the Government Rental Car Agreement, or the Smart Pay program. Contractors at a TDY location may ride in a rental car or government vehicle procured by an employee who is traveling if doing so is associated with the work of the contract's scope. There are 3 points to consider when determining whether a contractor can hold a travel program support role. 1. The type of contract the contractor is performing to or will perform to. 2. Whether the duties associated with the role must be performed by a federal employee, i.e., they are inherently governmental. 3. Whether the duties associated with the role can be performed by a contractor as overseen by a federal employee. The use of contractors to perform program support in the form of travel administration, including preparing TDY authorizations and travel expense voucher claims and arranging TDY travel on behalf of other employees, must be weighed against the Federal Acquisition Regulations, FAR. The federal travel regulation must also be considered as it assigns responsibilities to officials and sets standards for employees in general. We will first review the Federal Acquisition Regulations definition of a personal services contract. The rules set forth in the FAR must be carefully considered before allowing contractors to work on travel program matters. A. A personal services contract is characterized by the employer-employee relationship it creates between the government and the contractor's personnel. The government is normally required to obtain its employees by direct hire under competitive appointment or other procedures required by the civil service laws. Obtaining personal services by contract, rather than by direct hire, circumvents those laws unless Congress has specifically authorized acquisition of the services by contract. B. Agencies shall not award personal services contracts unless specifically authorized by statute, for example, 5 U.S.C. 3109, to do so. C. 1. An employer-employee relationship under a service contract occurs when, as a result of, I. the contract's terms or, 2. the manner of its administration during performance, contractor personnel are subject to the relatively continuous supervision and control of a government officer or employee. However, giving an order for a specific article or service, with the right to reject the finished product or result, is not the type of supervision or control that converts an individual who is an independent contractor, such as a contractor employee, into a government employee. C. 2. Each contract arrangement must be judged in the light of its own facts and circumstances, the key question always being, will the government exercise relatively continuous supervision and control over the contractor personnel performing the contract? The sporadic, unauthorized supervision of only one of a large number of contractor employees might reasonably be considered not relevant, while relatively continuous government supervision of a substantial number of contractor employees would have to be taken strongly into account. C. D. of this section. The FAR also provides guidance for assessing the nature of the work to be performed by a contractor. It is from paragraph D6, on the inherent nature of the service, that the 20 inherently governmental functions are defined. D. The following descriptive elements should be used as a guide in assessing whether or not a proposed contract is personal in nature. 1. Performance on site. 2. Principal tools and equipment furnished by the government. 3. Services are applied directly to the integral effort of agencies or an organizational subpart in furtherance of assigned function or mission. 4. Comparable services, meeting comparable needs, are performed in the same or similar agencies using civil service personnel. 5. The need for the type of service provided can reasonably be expected to last beyond 1 year. 6. The inherent nature of the service, or the manner in which it is provided, reasonably requires directly or indirectly, government direction or supervision of contractor employees in order to adequately protect the government's interest. Retain control of the function involved. Retain full personal responsibility for the function supported in a duly authorized federal officer or employee. The final portion of FAR 37.104 establishes certain other legal requirements and limitations which must be carefully considered before contractors are allowed to work on travel-related program activities. E. When specific statutory authority for a personal service contract is cited, obtain the review and opinion of legal counsel. F. Personal services contracts for the services of individual experts or consultants are limited by the Classification Act. In addition, the Office of Personnel Management has established requirements which apply in acquiring the personal services of experts or consultants in this manner, for example, benefits, taxes, conflicts of interest. Therefore, the contracting officer shall effect necessary coordination with the cognizant civilian personnel office. To begin with, the Federal Travel Regulation does not establish a role for a person to administer travel on behalf of an employee except as allowed by the regulations themselves. Instead, the regulation is shaped around the OMB-endorsed strategic intent that government employees administer their own official travel. From the FTR. eGov, Travel Service, ETS. The government contracted, end-to-end travel management service that automates and consolidates the federal travel process in a self-service web-centric environment, covering all aspects of official travel, including travel planning, authorization, reservations, ticketing, expense reimbursement, and travel management reporting. The ETS provides the services of a federal travel management program as specified in Section 301 to 73.1a, b, and e of this title. Secondly, eGov, Travel Services includes a travel management service that fulfills the requirements of Section 301 to 73.106, including making travel reservations for employees. Thirdly, the FTR prescribes how travel claims are to be prepared and submitted to the government based on the employee's records and knowledge of expenses they incurred. In accordance with 18 U.S.C. Section 287, the employee/claimant signs the claim to attest it is not false, fictitious, or fraudulent. Submission of false, fictitious, or fraudulent claims carries criminal liability. Given these points, so-called travel arrangers and travel preparers are actually administrative assistants, a resource role that is supposed to be addressed through the Federal Human Resources Program. Keep in mind FAR 37.104, F, which states, personal services contracts for the services of individual experts or consultants are limited by the Classification Act. In addition, the Office of Personnel Management has established requirements which apply in acquiring the personal services of experts or consultants in this manner, for example, benefits, taxes, conflicts of interest. Therefore, the contracting officer shall effect necessary coordination with the cognizant civilian personnel office. The department has analyzed the activities performed by persons acting as travel arrangers and/or travel preparers, as well as travel system administrators, and it has determined the activities constitute personal services. See determination matrix on next slide. Accordingly, a contractor who will perform these activities must be performing to a personal services contract. Before a contractor is tasked with performing activities associated with travel arrangers and/or travel preparers, a warranted contracting officer must have made a formal determination that the contractor is performing to a personal services contract and that the work is within the scope of that personal services contract. Additionally, only those contractors performing under an information technology services contract to operate the ETS as part of the system owner's responsibilities may act as travel system administrators. As a rule, contractors will not be allowed to act as travel system administrators beyond the system ownership realm. This chart shows the determination matrix for personal services. Pause the video and take a moment to review its contents. This chart is a continuation from the previous slide. Pause the video to review its contents. Notes: Superscript 1. A travel arranger is a person who makes travel reservations on behalf of other employees. Superscript 2. A travel preparer is a person who prepares travel expense voucher claims on behalf of other employees. Superscript 3. Government choose mode of transportation for employees. Superscript 4. Employee is responsible for travel expenses voucher claim. One major challenge of contractors performing travel-related personal services for employees is the risk of liability. When a contractor performs travel-related work, the employee who receives the services, who benefits from the contractor's work, remains personally liable. FTR Section 301-50.5, What is my liability if I do not use my agency's TMS or the eGov travel service, and an exception has not been approved? If you do not have an approved exception under Section 301-50.4 or Section 301-73.104 of this chapter, you are responsible for any additional costs resulting from the failure to use the TMS or eGov travel service, including service fees, cancellation penalties, or other additional costs, for example, higher airfares, rental car charges, or hotel rates. In addition, your agency may take appropriate disciplinary action. The employee receiving the services is still held to the Federal Travel Regulations standards for prudence, i.e., the Prudent Traveler Rules. Furthermore, for a contractor to act on behalf of an employee within the eGov travel system, the contractor must have the employee's permission. An employee use the eGov travel system's functionality to allow a contractor supporting their program office to act on their behalf. The contractor arranged travel for the employee to attend a conference in San Francisco at the peak of tourism season. The contractor, who said they consulted with the employee, made a 5-night reservation at a boutique hotel at a rate exceeding the statutory cap of the actual expense per diem method, and accepted the hotel's no-refund cancellation policy through the ETS. Within 1 hour of the reservation being made, the employee's supervisor considered the standards for travel set by the FTR and properly declined to approve the travel request as the trip was too expensive. The contractor immediately canceled the reservations and asked the hotel manager to waive the cancellation penalty. The request was declined, and the hotel charged the employee's IBA travel charge card for all 5 of the reserved nights. The employee filed for reimbursement and claimed the contractor who made the reservations was responsible. The claim was disallowed and the employee was held liable for the lodging charges, which totaled about $6,000. Additionally, because the travel had never been approved, The employee was not eligible for the FTR's cancellation reimbursement clause that allows up to one night's lodging expense to be reimbursed if the government cancels the trip and effort is made to have penalties waived. At the start of this module, it was noted that the use of contractors to perform program support in the form of travel administration, including arranging TDY travel on behalf of other employees and preparing TDY authorizations and travel expense voucher claims, must be weighed against the Federal Acquisition Regulations and the Federal Travel Regulation. As noted, the Federal Travel Regulation assigns a standard of care, prudence, to employees, not to contractor support. The FTR also prescribes responsibilities to employees, such as arranging their own travel and preparing their own voucher claims, while establishing a means to avoid risk. Employees can best avoid risk of incurring personal liability by using the FTR-compliant eGov travel services. The self-service model provided by the eGov travel system and the serving travel management centers are designed to minimize the risk of liability. An inherently governmental function is one that is so intimately related to the public interest as to mandate performance by government employees. COMBA 76. These functions include those activities that require the exercise of discretion in applying government authority, the use of judgment in making decisions for the government, decisions regarding monetary transactions and entitlements. Persons performing work for the government under a contract cannot perform these activities or act in a capacity that asserts they have actual federal authority. The Federal Acquisitions Regulation Subpart 7.5 lists 20 examples of specific functions that are inherently governmental. 1. The direct conduct of criminal investigations. 2. The control of prosecutions and performance of adjudicatory functions other than those relating to arbitration or other methods of alternative dispute resolution. 3. The command of military forces, especially the leadership of military personnel who are members of the combat support, or combat service support role. 4. The conduct of foreign relations and the determination of foreign policy. 5. The determination of agency policy, such as determining the content and application of regulations, among other things. 6. The determination of federal program priorities for budget requests. 7. The direction and control of federal employees. 8. The direction and control of intelligence and counterintelligence operations. 9. The selection or non-selection of individuals for federal government employment, including the interviewing of individuals for employment. 10. The approval of position descriptions and performance standards for federal employees. 11. The determination of what government property is to be disposed of and on what terms, although an agency may give contractors authority to dispose of property at prices within specified ranges and subject to other reasonable conditions deemed appropriate by the agency. 12. In federal procurement activities with respect to prime contracts. I. Determining what supplies or services are to be acquired by the government, although an agency may give contractors authority to acquire supplies at prices within specified ranges and subject to other reasonable conditions deemed appropriate by the agency. 2. Participating as a voting member on any source selection boards. 3. Approving any contractual documents, to include documents defining requirements, incentive plans, and evaluation criteria. 4. Awarding contracts. V. Administering contracts, including ordering changes in contract performance or contract quantities, taking action based on evaluations of contractor performance, and accepting or rejecting contractor products or services. Vi. Terminating contracts. 7. Determining whether contract costs are reasonable, allocable, and allowable, and 8. Participating as a voting member on performance evaluation boards. 13. The approval of agency responses to Freedom of Information Act requests, other than routine responses that, because of statute, regulation, or agency policy, do not require the exercise of judgment in determining whether documents are to be released or withheld, and the approval of agency responses to the administrative appeals of denials of Freedom of Information Act requests. 14. The conduct of administrative hearings to determine the eligibility of any person for a security clearance, or involving actions that affect matters of personal reputation or eligibility to participate in government programs. 15. The approval of federal licensing actions and inspections. 16. The determination of budget policy, guidance, and strategy. 17. The collection, control, and disbursement of fees, royalties, duties, fines, taxes, and other public funds, unless authorized by statute, such as 31 U.S.C. 952, relating to private collection contractors, and 31 U.S.C. 3718, relating to private attorney collection services. 18. The control of the Treasury accounts. 19. The administration of public trusts. 20. The drafting of congressional testimony, responses to congressional correspondence, or agency responses to audit reports from the Inspector General, the Government Accountability Office, or other federal audit entity. The Federal Financial Travel Approver, certifying officer, performs the following: holds pecuniary liability and responsibility to agency for certifying funds availability according to the time, purpose and amounts tests. Is the accountable official for certifying claims, per FTR. Directs federal employees. Interprets the application of law, the FTR, or travel policy. Needs to control activity. The Federal Supervisory Travel Approver, designated approving official, performs the following: authorizes employees to incur expenses by type and amount. Approves procurement of common carrier transportation. Allows/disallows amounts on travel expense voucher claims. Approves relocations or relocation-related travel expense. Directs federal employees to travel. Interprets the application of law, the FTR, or travel policy. Needs to control activity. The Travel System Administrator performs the following: interprets the application of law, the FTR, or travel policy. Needs to control activity, including signing claims on behalf of others. The Federal Voucher Examiner/Reviewer performs the following: conducts routine voucher and invoice examination. Note the following: Travel System Administrator excludes PSC System Administrator role, which is a system technician/systems operations technical role. The following roles are inherently governmental: Federal Financial Travel Approver, certifying officer, Federal Supervisory Travel Approver, designated approving official, and Travel System Administrator. The following role may be performed by a contractor, Federal Voucher Examiner/Reviewer. There are duties that are closely associated with inherently governmental functions. These may be performed by contracted staff with the oversight of federal staff. Example: support for a financial operations office that performs post-payment travel voucher claim audits or the processing of claims when there is a federal employee who reviews and approves the contractor's work. When there is a pay/don't pay decision associated with the contractor's work, a federal employee makes the decision and is the accountable official or signatory when required. The contractor does not work autonomously. For closely associated duties, a determination must first be obtained from the contracting officer that the type of contract is appropriate, the travel-related work activities are in the scope of the contract being performed to, and the work is not inherently governmental according to the standards and determinations made by the department. Because certain travel program-related work has already been determined by the department to be inherently governmental, the associated eGov travel system roles cannot be held by contractors. Travel System Administrator. Federal Financial Travel Approver/certifying officer. Federal Supervisory Travel Approver/designated approving official. These determinations are factored into the eGov Travel System User Management Plan used to obtain the system's authority to operate/permission to operate. If it is determined that a contractor improperly holds one of these roles, then the contractor's access to the ETS will be terminated and the violation reported to the contracting officer responsible for the contract. Before concluding this module, we will look at a case study where a contractor was improperly given an inherently governmental ETS user role. A contractor improperly allowed to have the eGov Travel System Administrator user role caused an employee's claim to be delayed and caused work for other programs. The Program Support Center had to step in to fix the many issues caused by the contractor in order to enable the claim to process. A program management review of the event determined the contractor was performing an inherently governmental function as well as performing work beyond the scope of the contract. Had not been trained how to perform travel system administration. Made repeated adjustments to an employee's travel expense voucher claim by adding and deleting expenses as the claim processed and without understanding how the system functions. Caused payment to be delayed while the issue was resolved. What type of contract must a contractor be working within the scope of in order to prepare temporary duty travel authorizations and travel expense voucher claims for an employee? A. A time and materials contract. B. A firm fixed price contract. C. A sole source contract. D. A personal services contract. Pause the video, consider your response, and then resume to learn the answer. The correct answer is D. A personal services contract. How does a contractor performing to a government contract arrange their travel when it is necessary to accomplish work within the contract's scope? A. By using the eGov travel system. B. Through the eGov Travel Services Travel Management Company. C. Through their company's procedures and resources. D. By being set up as an invitational traveler. Pause the video, consider your response, and then resume to learn the answer. The correct answer is C. Through their company's procedures and resources. May a contractor use strategic sources like Fed rooms, eGov, travel services, or city para-program fares? A. Yes, they may use strategic sources if the contracting officer agrees. B. No, they may not use strategic sources. Pause the video, consider your response, and then resume to learn the answer. The correct answer is B. No, they may not use strategic sources. How is it determined whether a contractor may travel in the performance of work within the scope of a contract? A. Yes, they may. The contractor's work meets certain criteria established in the Federal Travel Regulation. B. The provisions of the contract apply and/or the appointed contracting officer or their representative determines the travel is necessary. C. The contractor's manager determines the travel necessary. D. The senior travel official determines the travel is necessary. Pause the video, consider your response, and then resume to learn the answer. The correct answer is B. The provisions of the contract apply and/or the appointed contracting officer or their representative determines the travel is necessary. Which statement best represents the relationship of the Federal Travel Regulation, FTR, to contractor travel? A. The FTR establishes provisions for contractor travel under Chapter 305, Payment of Travel Expenses for Government Contractors. B. Incorporating the FTR by reference into a contract establishes eligibility for the contractor to be covered by all aspects of the regulation. C. The FTR does not apply per se to contractor travel, but some contracts may incorporate sections of the FTR which must then be adhered to. D. As legislative rule, the FTR applies only to those persons it defines as employees, and no regulations therein may be applied, even by reference, to contractor travel. Pause the video, consider your response, and then resume to learn the answer. The correct answer is C. The FTR does not apply per se to contractor travel, but some contracts may incorporate sections of the FTR which must then be adhered to. If a contractor, other than the government sea travel services contractor, acts on behalf of an employee in making travel reservations, who is responsible for the liability? A. The employee, because the contractor must have the employee's permission to act on their behalf and the FTR assigns liability to the employee. B. The government, because local program preferences establish policy. C. The contracted company, because its employees must perform to the scope of the contract. D. The contractor employee, because they assume liability by performing the company's contract work. Pause the video, consider your response, and then resume to learn the answer. The correct answer is A. The employee, because the contractor must have the employee's permission to act on their behalf and the FTR assigns liability to the employee. If a contractor reserves a non-refundable airfare requiring immediate payment, but the TDY authorization request is not approved, who is liable for the cost of the airfare? A. The government. B. The contractor. C. The airline. D. The employee. Pause the video, consider your response, and then resume to learn the answer. The correct answer is D. The employee. How does eGov Travel Services reduce the risk of liability? A. It provides federal travel regulation compliant travel services. B. It ensures that contractor support staff do not make errors. C. It prevents employees from making errors that carry liability. D. It does not reduce risk of liability. Pause the video, consider your response, and then resume to learn the answer. The correct answer is A. It provides federal travel regulation compliant travel services. Choose all that apply. Which of the following activities has the department determined to be inherently governmental functions that cannot be performed by contractors? A. Arranging employees' travel. B. Certifying funds. C. Preparing travel expense voucher claims. D. Adjudicating travel claims appeals. E. Providing Tier 1 travel support. Pause the video, consider your response, and then resume to learn the answer. The correct answers are B, C, and D. Certifying funds. Preparing travel expense voucher claims. Adjudicating travel claims appeals. True or false? Contractors may perform duties closely associated with inherently governmental functions only with the oversight of federal staff. Pause the video, consider your response, and then resume to learn the answer. The correct answer is true. What must occur before a contractor or subcontractor is tasked with travel-related work? A. The program office must confirm with the contracting officer's representative that the travel-related work activities are in the scope of the contract and the work is not inherently governmental. B. The federal program manager must assess the work to determine whether it is closely associated with inherently governmental functions and is being performed under a personal services contract. C. The program office must submit a justification to the contracting officer for a waiver of the personal services contract requirement and agree to supervise the contractor's work. D. A determination must be obtained from the contracting officer that the type of contract is appropriate, the travel-related work activities are in scope, and the work is not inherently governmental. Pause the video, consider your response, and then resume to learn the answer. The correct answer is D. A determination must be obtained from the contracting officer that the type of contract is appropriate, the travel-related work activities are in scope, and the work is not inherently governmental. Which three of the following eGov travel system user roles have been determined to be inherently governmental? A. Travel arranger. B. Certifying officer. C. Approving official. D. Travel system administrator. Pause the video, consider your response, and then resume to learn the answer. The correct answers are B, C, and D. Certifying officer. Approving official. Travel system administrator. If an employee relies upon a contractor to make their travel reservations for them and the contractor makes an error such as accepting an onerous lodging reservation cancellation policy, who is liable for the error? A. The contractor. B. The contractor's company. C. The government. D. The employee. Pause the video, consider your response, and then resume to learn the answer. The correct answer is D. The employee. What is the primary risk of having a contractor prepare a travel expense voucher claim for an employee? A. The contractor does not have first-hand knowledge of the travel expenses incurred. B. The contractor cannot be held liable for the preparing of inaccurate claims that result in improper payments. C. Errors, including omissions or inaccurate itemizations, can establish a claim submitted as false, fictitious, or fraudulent, for which the claimant might bear criminal liability. D. The contractor is performing a job that must be done by a federal employee. Pause the video, consider your response, and then resume to learn the answer. The correct answer is C. Errors, including omissions or inaccurate itemizations, can establish a claim submitted as false, fictitious, or fraudulent, for which the claimant might bear criminal liability. Congratulations! You have completed this episode. Thank you for participating. The next episode in this series is Episode 16. eGov, Travel System Permissions and Roles.